Welcome to tonight's asset protection webinar. As most of you know, if you've been with us a long time, this is a long-running asset protection class. We've been teaching webinars well over 15 years, and very happy to have you aboard. If you're brand new to us, we do record the webinars that we do, and we keep those. Not all of them are available on YouTube at any one time, but there's so many really good webinars that we've done. If you will subscribe to our YouTube channel, so go to YouTube, type in Protect Wealth Academy. I would say we've got well over 300 hours worth of recordings available to you at any one time. And we got some really great topics on asset protection, wealth creation, estate planning, income tax reduction. There's a library of information, and we've got some really good webinars coming up soon. So pay attention to your emails, but also if you'd like a particular topic, you can generally find it on our YouTube channel. And then we've got a new series that we've started posting tax tips on our Facebook channel, and just kind of random little fun things that we run into here and there. So pay attention to those, and if you'll like us or connect with us on Facebook, then there's a lot of articles that we'll post. If we see something new we want you to be aware of, we'll post that generally on Facebook. And then we've got 2 more summits coming up this fall, one in September, one in November. These are always Monday, Tuesday, Wednesday classes. We bring in Scott Estel, a former senior trial attorney from the IRS, to teach taxes. Clint Coons, an amazing real estate investor, asset protection attorney. Mike Koval and his sister to teach some simple tax or stock market strategies. Bill Danko, co-author of The Millionaire Next Door. We've got quite a lineup, and we change it every time, a little bit here and there. And so we always bring in some new faces, and so attend that. And if you haven't attended it for a year or more, you need to come back for a refresher course. So if you would sign up for that at protectwealth.com. The classes are free, but we're very serious about attendance at this. Because what we do, in fact, the theme of the class is a lifetime to accumulate, 3 days to protect. What we don't want you to do is come in and out, learn half a strategy, half a tax strategy, think you understand the legal concept, and then go out and become dangerous. So give us 3 days. But we're very good at teaching, and we teach in a sequential, logical manner that I don't care if you're sophisticated or brand new. We've got something for everyone. At the end, I'll always take the last couple hours and teach case studies. Remember when Clint talked about this, remember when Scott talked about this, and I'll tie it together in some case studies. And that for most people is kind of the aha moment where we put it all together. And we welcome you to that class. It's an amazing class. So before we teach tax and legal, and I introduce you to Josh, I don't care if you read the whole thing, but we can't teach specific legal concepts. We teach general principles. How they apply to you, I don't know. So we always give you an opportunity to meet with one of our attorneys or somebody that we select, but don't just take a legal concept and think that it applies to you, because quite often we're teaching a correct principle, but the relevance may or may not be there. So with that, we were talking to Josh before. Most of our most of our students that come to us have real estate of some kind, and there are so many misconceptions, misunderstood concepts, or just your attorneys are saying, well, just have a single member LLC and you live in Florida and it's great asset protection. Well, it has corporate veil protection. It can protect you from what happens inside, but somebody that sues you personally, that take those things away. There's so many tax traps in the tax code. We call them tiger traps. You're walking through the jungle, you fall on a tiger trap, there's spikes, and There are tiger traps all the way through the tax system to catch unsophisticated real estate investors. And if you don't know the tax side and get labeled, for instance, with dealer status, or you didn't understand capital gains, and you're just buying and selling and flipping houses, and you're going to get eaten up if you don't understand the tax and legal sides and the lawsuits that can come. You have to understand these concepts. And I used to think that they were so complicated. Oh my gosh, they're not. There's some simple concepts. Once you understand the basics and have somebody guide you through them, this is why we brought Josh on. He's an expert for real estate and for tax. Well, Josh, we're excited to have you here. I'll let you kind of give your own background, but you're a senior advisor with Anderson Law Group. You've been teaching this a long time. Josh, welcome. Thank you for taking your time to be here with us tonight and with our students. And looks like we're growing in number, and we got a good audience for you tonight.
Excellent. Thank you for having me. I'm excited to be here. Don did a great job introducing me and the topic. Briefly about me, since I am going to be spending some time with you tonight, just like you to get to know me just a little bit better. So I've been doing asset protection and estate planning and some tax planning for 8 years. And in that 8 years, I've been able to help hundreds of people structure their assets to protect themselves and their families and their legacies from anything that can possibly happen, from tenants getting injured, from people suing over a car accident, from any other types of legal liability that you can think of. I've probably talked with somebody that has experienced it, or I have, worked with them and their people to help them to make sure that these things don't have to happen. And that's really the takeaway. Exactly what Don said. This doesn't have to happen to you. There are simple, basic principles and strategies that we're going to talk about tonight that will allow you to protect yourself and provide for your family and simultaneously reduce your tax liability. So I'm an attorney licensed in Utah and New York. I realize it's a little bit of an odd pairing, but I do have both of those licenses. And I did my legal education in Sacramento, California. So I've been to both of the big bad places on the coasts, worked there, have a good understanding of how the law shouldn't work, in my opinion, and ideally how it works well for us as well. So the topic tonight that we're going to be talking about today is...
So Josh, do you want to take questions at the end? Is that okay if they hold their questions to the end? And all right, so you go ahead and take control of the screen. I'm going to stop sharing mine and give you total access there, bud.
Wonderful. Thank you so much, Don. All right. So yes, hold the questions till the end and I will take as many as I can. Happy to do that. Today, we're going to talk about real estate tax and asset protection strategies that can save you thousands of dollars. So we're going to talk about the principles. We're going to talk about the strategies. Questions will come at the end. And please, as you have them, I believe we're going to use the question and answer box on Zoom. So look for that feature, put them in there, and I'll answer them after we've covered the information to cover tonight. Just like Don said, while I am an attorney, I'm not your attorney. I would be honored to be your attorney, but we're not in that position yet. So while these principles are generally applicable, we need to take several more steps before we can come up with something that is specifically applicable to you. So Anderson Business Advisors, I work there, or here rather, and they've been around since 1999, and we've helped thousands of people structure their assets, save taxes, and protect themselves from the risks that beset people that are trying to just build wealth and create a legacy. Now, what are we going to talk about tonight? So tonight we're going to talk about 4 specific things and a lot of little things building up to those 4 things. First, you're going to learn about how to obscure your assets legally so that your ownership doesn't show primarily and publicly in databases that are available to everyone in the United States. Second, we're going to learn about a specific real estate investing strategy that can leave you with 4 different distinct paydays. Then we're going to talk about how you can use the tax code to have the government essentially pay for your down payment on investing in investment real estate. And finally, we're going to talk about how to permanently defer capital gains and put your family in the best possible position to receive those assets when the end comes for all of us. So that leads us into the first basic principle that we're going to talk about tonight. And that is, what is an entity? What makes an entity useful? Why do we want entities? And why are entities really the bread and butter of the whole system of asset protection? Okay, so entities are people under the law. In legal parlance, it is accurate and appropriate to say that while I am a person under the law, so too is a corporation or a partnership or a limited liability company considered a person under the law. Specifically, what that means is that the entities, or me, myself, can enter into business negotiations, contracts, different business dealings with other people, entities, or natural people. Furthermore, those people can sue or be sued in their own names. And most importantly, those people can hold assets. Now, just for sake of clarity, moving forward through tonight, when I talk about people, I will be referring mainly to natural people, living, breathing people. And when I talk about entities, what that will represent are the business formations that we create to help protect assets. One way that this difference is important is in how people versus entities are taxed. We'll talk more about that in a little bit, but the important takeaway right now is that entities get to choose how the tax code applies to them. People do not. The tax code just applies to all of us, more or less the same. And so when you hear about people manipulating the tax code, it's not that a person is doing that. What is happening, as many of you probably know, is that a business entity is taking advantage of some portion of the tax code that allows them some beneficial treatment. That is what's happening. So the important thing to take away here is that there are entities that when we create them and go through the necessary steps to create them, they become separate legal persons. And because they are separate legal persons, they are entities, they own their own assets. And you having an ownership interest in that entity, when the entity then owns another piece of property or a different asset, that is not the same as you owning the asset in your own name. Those things are two different things. And what this does is this leads to the next principle, which is understanding the differences between liability, when liability takes effect, and how liability takes effect. The best way to understand this is the difference between inside liability and outside liability. So first, defining terms. Liability is legal responsibility for an event that has occurred or may occur in the future. Usually that comes down to money. Somebody, whether an entity or a person, has to pay for something under the law because of negligence or a mistake or a misunderstanding. That's liability. Whether or not liability is inside or outside depends on the asset that gave rise to the liability or the event that caused the liability, as well as how that asset is owned. So who owns it and how that person owns it is what's important. An example of inside liability, starting there, would be the situation where you are driving down the street and you cause a car accident. that liability is inside to you. You were the one that caused the event. You had the car that caused the event, and you owned the car that caused the event. That's inside liability, meaning that you, the person, are going to have to pay for anything that happens as a result, any injury that occurs as a result of that incident. Now, how could we make that same situation outside liability? It would be outside liability if you owned a business entity, a limited liability company that owns a bank account. For that business entity, in most cases, the car accident is outside liability, meaning that the business entity that holds the bank account doesn't own the car. That business entity had nothing to do with the car. And therefore, the damages that occurred because of that car, that's outside liability for the entity. Entity doesn't have to worry about it. Now, if we change the hypothetical to get a better sense of how an entity would handle inside versus outside liability, we need to have a different limited liability company that this time owns a piece of property. So there's a single family property and the entity owns it and you own the entity. Okay, somebody slips and falls, hurts themselves, and they say that you, the owner of the property, are liable. You say, no, not so fast. I own the entity that owns the property. The responsible party is the entity, not me, so long as certain business compliance steps are taken. Now, what does that mean? Well, what it means is because this legal entity, this company, has been set up appropriately, the person alleging liability, the tenant, is only able to sue that entity. And as long as the entity business compliance requirements have been met, the tenant is not able to target you or your assets personally. For you, that is an outside liability. So understanding the difference between inside liability and outside liability is crucial to understanding how entities and the formation and use of entities is going to allow you to protect your assets. Entities are a creature of state law, meaning that you won't find in the federal rule books or the federal code a statute that says you are allowed to create a corporation or an LLC. Instead, each of the states have their own statutes allowing for the creation of business entities, partnerships, limited liability companies, corporations, and other types. But those are the three main ones. And so different states have different rules as to what will and will not be allowed to do business through that entity. They also have different statutes available, that will allow you to choose a statute that is most preferable to you. The other thing that we mentioned with choice is you get to choose taxation with entities, specifically with limited liability companies. Now, the main difference between how an entity is taxed versus how a person is taxed is demonstrated by this slide, okay? So natural people, the people that live, breathe, talk to each other, walk around, they have to earn and be taxed on their earnings in the following order: earn, tax, spend. That's how it will always work. Whereas for a juridical person or a business entity, we can flip the taxation and the spending part so that businesses get to earn, spend money, and then they are taxed on what's left, whether that is a lot, a little, nothing, or even a loss, right? Negative earnings. And so understanding the three principles that we've talked about: entity separation from individual assets, the difference between inside and outside liability, and how entities are taxed different from natural people, along together with the selection of how to be taxed in an entity, allows you to make determinations in structures that will help you to protect the assets, obscure the assets, and save money on taxes. Now, there are 4 main types of taxation. As you see here, we've got sole proprietorship, which is just people that go out and start a business. If you think of a kid on the street opening up a lemonade stand, legally, that would be a sole proprietorship. And then there's no filing of documents necessary. And with the sole proprietorship, because no documents have been filed, no separate legal formation or entity has been brought about. So there's no separation of assets between the business owner and proprietor and all of their assets and the assets of the business. So sole proprietorships, you don't want to use them. With a disregarded entity, what you've done is you've created a single member LLC. What that means is that you have one owner, a member of an LLC is an owner of that LLC. And that person has decided that for IRS tax purposes, they don't want any taxation to have to occur. So they have checked a box that says this entity is going to be disregarded. And that means that all of the money that is made from that entity and its separate assets is going to flow through or pass through to the individual member or owner's tax return. And the gains or losses will impact that individual's tax return instead of the separate tax return of the entity. Important thing to note here is that this is where liability and taxes differ. You will notice that because the entity was formed with the state, that entity is separate. It's a distinct legal thing from the natural person. And because of that, the assets of that entity and the assets of the person are going to be different. They're not going to be held as being the same. Whereas the taxes can be treated the same. So liability is still different, but the tax liability is the same and it collapses in on itself. It's important to understand that this tax lens of asset protection and the liability lens of asset protection sometimes overlap and many times do not. And that is normally by design. We design that into all of our structures to help people achieve their different goals and desires. The next type of entity you have here is a partnership. And that's both an entity type and a taxation method. So when we're talking about a partnership, we have to distinguish between, is this a partnership in the sense that this is a partnership entity, or is this an entity like an LLC that is taxed as a partnership? Those are different things, same word. And so here's just another example of when the terms that we use can be the same, but have vastly different meanings. And it's easy to talk past each other, even for someone who, like myself and my colleagues who have been in this world for a long time, it still takes time to make sure that we're talking to the same point with a lot of these terms. The last type of tax that you can elect to have for an LLC is what's called a corporation. And there's 2 types of corporation. Here again, we have the same issue with a partnership. A corporation is a type of entity. It is also a taxation method that may be applied to a limited liability company or an LLC. You have C corporation taxation status and S corporation taxation status. C corporation, the C refers to subchapter C in the Internal Revenue Code, just a little bit of nerdy lawyer trivia. And that is generally dealing with what we perceive or think of in America as the bigger companies, companies like Disney, Walmart, Amazon, all of those companies, those are C corporations. Whereas S corporations, again, the S stands for subchapter S in the IRC, the Internal Revenue Code. Those, a lot of people use the mnemonic S stands for small because there are ownership restrictions in the tax code for how many owners S corporations can have. And so those are the various tax methodology types that are applicable to the various entities. Now, lots of theory so far, but we haven't really talked about or dove into how this is applicable to you in various scenarios. I'd like to do that now, and that's really going to be the rest of our time together. Is we're going to go over examples and hypotheticals to apply the principles that we've talked about and discuss together how these things are going to be effective for you. So I'm going to turn my attention to my other screen here. Give me just a moment. And what we're going to do now is look at typical structures that are going to be applicable to a lot of folks. So the first structure, the first thing we're going to talk about is outside liability generally. So if you have a situation where you have no asset protection, it's just you doing business. So let's say that we have you here, and you have 5 or 6 different houses. And you're doing pretty good, right? All of them are rented. Everybody's doing well. Very much like the scenario that Don was talking about earlier before we started, where you could have a lot of equity built up in these properties. Well, what happens if tenant 1, right over here, gets injured and they sue the owner of the properties? Well, that's you. And because you own, right, the investment properties in your name, and you own your car, maybe you're a doctor, right, and you own a medical practice in your name, or a lawyer, right? And maybe you have, a nice vacation property and a boat, and you have all the great things, right? Well, because you own all of these things in your own name, the tenant that injured him or herself and is alleging that you are the cause of the injury, they're going to be able to target all of those assets, because this is all liability that is attached to property here that you own, and therefore the liability attaches to you, right? All right. So now let's take that same scenario and let's just put a little bit of asset protection in that, right? So with even just a little bit of asset protection, we can limit the damage. So in this case, we have you're down here. I'll give you arms this time. I forgot last time. You've done very well for yourself without any arms, but this guy has arms. So let's see. Now, in this instance, this individual owns an interest in an LLC. So this is the LLC. And then inside that LLC, he has the same 5 houses. Why is that doing that? Okay, he has the same 5 houses. This time, when the tenant gets hurt and sues for this property because alleging that the owner of the property was negligent, where does the liability attach, right? Now, because we have this entity in the way, the liability doesn't attach to you. That's not where that goes. Instead, the liability for the damages suffered by the tenant, right? He has a neck brace on because he's trying to milk it for the court. That liability attaches to the LLC. Now, still not an ideal scenario, because now all 5 of the properties, the equity that you have in those properties, is at risk from being taken in the lawsuit. However, all of this stuff that's located or owned outside of the entity, the medical practice or legal practice or pharmacy or manufacturing company, is protected from this tenant, right? The family car, the vacation property, the boat, all of the personal assets are protected from the tenant suing because it's owned in a different entity. It's not owned by the LLC that had the property where the incident occurred leading to the liability, okay? So that's just one example. But what if we took this even further, right? What if we extended this out so that we could protect all of the assets more or less equally and lose even less of the assets? Okay, so let's look at what that might look like. So here in scenario number 3, we have you again, and you have an LLC. But you didn't stop there. Now you also have 5 subsidiary LLCs. These 5 subsidiary LLCs are all owned by this holding company. Then tenant comes and alleges an injury. Applying the principles that we've learned, it's very clear that the liability for the injury is going to lay where? It's not going to lay with entity number 2 that owns property 2 or 3 or 4 or 5. It's going to land right here. And some of it may trickle up here, right? They might bring a lawsuit there and try to enforce the judgment there. But interesting thing to note about lawsuits, lawsuits can go what's called up the chain of ownership, but as long as the legal compliance steps have been taken in this entity, liability can't then go back down the chain of ownership. So it won't affect entity 2 or 3 or 4 or 5, right? Now, how do we make sure that even though the assets are protected, maybe you don't want, people knowing who owns the property? Nothing is more terrifying for real estate investors than to have the tenants, particularly disgruntled tenants, know where they live. I've talked to people before that have said, I like that we own properties and I'm glad that we can rent land to people, but it's really scary when disgruntled tenants show up because they know where I live and my kids are playing out in the front yard. And then some guy that's angry because, he violated the lease terms and got kicked out is coming over to my house to bother my family. That's upsetting, obviously so. So is there a way to anonymize the ownership of the property as well as protect the assets? The answer is yes. So in this scenario, what we have is we have you. And here again, we're going to create the holding company. If you can't tell already, blue, when I have blue, that usually means holding company. Now, in this case, we're going to choose a specific state to create this holding company in. And the state that we're going to choose is Wyoming. Now, why Wyoming? There are 2 reasons we use Wyoming, usually for our holding companies. The first is anonymity. When you file and appropriately file a Wyoming entity with the state, your ownership information isn't taken down and it's not stored in a state website or database. Therefore, that information can't be shared publicly with people, right? Can't be done. They don't have it. How could they share it? And this anonymizes this person from anybody that's going to try and snoop and see who owns the properties. Because if I can find out as an attorney who owns the properties, maybe I can reverse engineer a search where I can see if they own anything else that I might be able to kind of wiggle my way into and apply liability to. But by choosing the right state to create the entity in, and you do have a choice, it doesn't just have to be the state where you have properties, for the holding company at least. Choosing the right state for the holding company allows you this anonymity. So that's reason 1. So reason 1 for Wyoming, we're just going to abbreviate that to anonymity. The second reason that we use Wyoming as a business entity for the holding company is the charging order. Now, The charging order is best explained and demonstrated by application of the principles we've been talking about, okay? So let's say, you'll notice, same hypothetical, where we're evolving in our understanding of these asset protection principles. So now we have all of these homes owned in their own LLCs. And these might even be in different states. Maybe you have Ohio, Iowa, Alaska, Mississippi, and Alabama, right? So you have a house in each one of these states. And we've picked on number one enough. Let's say that in this case, number two, Iowa, has the accident and is bringing a lawsuit. So they sue the entity. And because we have the asset protection structure set up this way, the only entities they're going to be able to face are these right here, right? The Wyoming entity, the Iowa entity. None of the other entities, Ohio, Alaska, Mississippi, Alabama, are going to be affected by this lawsuit. Now, we'll even go worst case scenario to highlight the importance of this charging order. Worst case scenario, the tenant wins the lawsuit against the Iowa LLC, and they have a judgment now against the Iowa LLC. Well, because the Iowa LLC is wholly owned by the Wyoming LLC, they have to go and enforce the judgment against the Iowa LLC and the Wyoming LLC. So what are they going to do? They're going to go to Wyoming and they're going to say, Wyoming court, I have a judgment here that I want to enforce against Wyoming LLC. And the court's going to say, that's very nice for you. And they're going to say, let's see the judgment. And the judgment's going to say, you get this much money. And the judge says, great, that's a valid judgment. We're going to enter it into the record. So far, this isn't looking very great for our intrepid real estate owner. But this is where the tables start to turn and things start to get better for him. Because this charging order is the key to the statute, is the key to the statutory protection for the LLC. Charging order is a legal limitation for remedies available to creditors, people who have judgments. And the legal limitation in Wyoming is that once a person has a judgment against a Wyoming entity, they are limited to receive distributions from the entity that would otherwise go to the member of the entity. Translating that from legal jargon into plain English, that means that the tenant who won the lawsuit gets to stand in the shoes of the owner of the LLC when distributions are made from the Wyoming LLC. A distribution is a very specific legal type of movement of money from the LLC to the owner. It is not a salary. A salary is not a distribution. A payment for a customary, ordinary, reasonable, or necessary tax-deductible business expense is not a distribution. Paying money to one of these subsidiary entities for repairs, maintenance, or remodel, not a distribution. The effect of this charging order is that you, as the owner of the Wyoming LLC, per the statute, you get to decide whether or not and to what extent distributions are going to happen. What does this mean for the tenant who brought a lawsuit? Well, it means that they're sitting out in the cold and waiting for money to be distributed to them. And they have absolutely no legal recourse to force you to make a distribution. And so by choosing not only to create entities and comply with the necessary legal requirements to keep the entity active, but also in choosing where to put the entity and how to utilize the entity strategically, we've been able to create a situation where, one, it's going to be hard for anyone to find out that you own the property because of how you set up the entities. Two, even if they do have an injury that's legitimate and sue you, they're going to run into a wall where they can't get money out of the entity because you get to decide whether or not to make that distribution. And all of this leads to the main conclusion that we want to have which is the lawsuit never happens. It's too hard. It's perceived to be too much work for people to go after these assets. And so they don't. They leave them alone. Now, let's do another variation on a theme. Okay. So this time we have the real estate investor, and this real estate investor has a holding company and the same kind of structure, running out of space. But let's say this person also has an active business entity, right? So this situation, I believe it's number 5, is an actual real life case study from a client that I'm working with right now. This client owns a business in a fairly litigious state on the west coast of the country. And this business has been doing a good amount of business, and they were doing just fine until one lawsuit came and wiped out the company. It took one lawsuit from one person who bought a product and was unhappy with the product to cause all of this problem that this client is now experiencing. Let's call the client Bill. Bill calls me up. Bill goes, Josh, I have a problem. I said, Bill, tell me your problem. Bill says, look, have this company selling widgets. We sold a widget to somebody who used the widget the right way, but got hurt and says it's our fault. And the court and the jury agreed with the client or the consumer. And now I have this judgment. And we had a very long conversation about what options Bill had that may or may not be the best choices. We had a very long conversation. And then during this conversation, Bill said, I forgot all about this other question that I have, which is, how is this going to affect all of my other entities? How is this going to affect all of this right here? And I said, well, Bill, have you filed the necessary papers to create these other entities? Bill said, yeah, I have. I said, okay, great. Have you established bank accounts for each of these entities? Yes, I have. Good. You keeping regular books and records for the entities? I am. Fantastic. And then I said, Bill, I have good news. None of those entities are going to be affected by the lawsuit that happened here. Yeah, it stinks that this lawsuit happened and that you lost. But we've talked about the options that you had. You should go back and talk to your local legal counsel about those options, but your other assets are protected, right? You don't have to worry about those anymore. At least in this instance, this lawsuit is not going to hamper, hinder, or affect in any way these other properties. It's not going to happen. Okay. And Bill walked away very relieved. Now, Bill slept on it for a while and called back because such is the nature of things that we don't understand fully. We want to, sometimes we come up with ideas that are not as helpful or useful for us. and they call back and we talk to them again. But that is a real life example of what asset protection can do. When you have the entity set up in the right way, in the right jurisdictions or in the right states, you are able to utilize the structures in a way that aren't going to affect your other assets. Another example that I want to share with you. In this case, we have Cody. Now, Cody has some real estate, right? So our typical structure has been set up here. However, Cody has a lot of ongoing business activities. And particularly in this entity, he's got, let's say, $5 million of equipment that he uses routinely to do work that makes his income. One of the operators of this equipment caused an accident and severely hurt someone. And a lawsuit was filed, and Cody, I was actually just on the phone with Cody, I think yesterday. And Cody said, we got one of those lawsuits settled, so that's good. And I said, oh, that's really good. He said, but I don't know about the second lawsuit that's coming. And I don't know what I can do to protect my assets in the meantime. Now, Cody and I were able to discuss potential options and come up with a plan that will work for him. However, the plan that works in scenario 6 here would not have worked in scenario 5 that we just talked about with the widget that went wrong, right? And the reason is because of other legal principles that apply to when you can and cannot move assets. The point of this particular case study is that asset protection, although the principles are the same and are fundamental to everyone, the application of those principles must be done in a personalized way in order to gain the desired benefit. You and your friend may even have exactly the same properties, but you're using them in a different way, and the use of those properties would require a different strategy. Okay, so the point of this asset protection structure here is that 1, it's personalized. 2, it's not difficult to set up if you have the right mindset going into it and you have a good guide moving forward to guide you through what you need and when you need it and why you need it. Okay, now let's talk about how different tax statuses applied to these different structures can have vastly different effects on how your investing may go into the future. So opportunity 7, we have our typical person. Let's give an arm, give him arms, come on. All right, we have this individual here. And this time, right, we have the same type of thing, but we're not going to focus on the liability aspect of it this time. This time, we're going to focus on the tax status. So how is this and these entities, how are all of these entities taxed? Okay, well, there are a lot of different options. The typical option we see is have this entity, the holding company, taxed as a disregarded entity. And then you have this entity taxed as a disregarded entity, or these entities, excuse me. Now, why would we want to do that? Well, that's because when we have money coming in from tenants, that is a lot of money, coming in from tenants, there's no tax filing here, and there's no tax filing here, and instead, all of the tax implications for these entities, the gain or loss, is reported on our real estate investors 1040. That's good. You have all of the asset protection that these entities provide for you, and you only have to file one tax return, a tax return that you were gonna have to file anyway, right? However, let's say that you go in to buy your 6th rental property per our hypothetical that we keep reusing. So now we have this structure here. You got 5 properties, but you're looking at property 6. And you need a loan, right? And you have all of this income coming in, right? So we know that this is money from tenants coming in and landing on our real estate investors 1040. If all of these entities are disregarded for tax purposes. So we have disregarded entities here, and we have a disregarded entity here. That's great. But if you go for property 6 and try to get a Fannie Mae or Freddie Mac qualifying loan, they're going to ask for what? Your tax return. And what they're going to see on the tax return is they're going to say, oh, we see that you make, let's call it $5,000 a month, right? $1,000 per property. Great. We're going to have to discount that to 75% of your earnings. You will protest. You say, sir, I protest. They say, why do you protest? They'll say, I don't make only 75% of that. I make 100% of that every month. And they'll say, that's great. But to have a Fannie Mae or Freddie Mac qualifying loan, we can only accept 75% of this income because of how it's reported on your tax filing. So this one change that we're about to make could save you a lot of money, because you can go out and afford to get other people's money through the means of a loan to buy this other property. Use some of your money, mostly other people's money, and get somebody else to pay you to have this new property. So how do we do that? Well, we do it by having this entity taxed as a partnership. So this entity will still be an LLC, but when we create the entity, we will elect to have it taxed as a partnership. Why will we do this? Because for those of you that are more knowledgeable about taxes, you will notice and correctly point out, but Josh, the tax flow of money is the same. To which I will respond, you are right. However, where it is reported on the 1040 matters here. If it's reported on one of the schedules, it is counted 75% of the income for a qualifying mortgage. However, if it is, and I believe that's Schedule E, I could be wrong on that. We'll have to fact check that particular part. However, if it's reported as part of a K1, which a partnership return kicks off and adds to the 1040, then you get to use 100% of the income from these entities to qualify for a loan for Fannie Mae or Freddie Mac qualifying mortgage loans. How does one have a partnership entity? It's very simple. You have to have 2 members. In all of the previous hypotheticals that we've looked at, you've only needed 1 member, just one. That's what's called a single member LLC. For a partnership entity, you have to have at least 2 members. Now, if you're married or you have a very close business partner that you work with, finding a partner is easy. You've got one built in if you're married. If you have a business partner that you work closely with, you've got a person that you've developed a relationship with where you can do this. How do you get this benefit of partnership taxation if you're only one person, though? It's a very good question that has a very simple answer. All you have to do is create another entity. So then what we have, let's actually change the color of that. Sorry. So then what we have is we have the real estate investor that owns 100% of this entity. And then we have the holding company that is owned by this entity, maybe 1%, and this person, maybe 99%. This entity, for tax purposes, will be, everyone say it with me, disregarded. And that way, you can still get the same benefit flowing into your personal tax filing with only one person if you need to. So there are ways to move around the legal requirements, again, in a legal and an effective way to gain the benefits that you're looking for depending on how you're looking to do your deals. Now, let's take a look at a strategy whereby you can invest in property and have the federal government get to have, goodness sakes, where you can get the federal government to pay for the down payment. Okay, how does that work? Well, how that works is we're not going to focus on the structure here so much. We're going to focus on different things that have to do with one of your investment properties. Okay, you have an investment property. Investment properties, if it's a single family residential property, you're going to depreciate that property over a useful life of 27.5 years. And if it's a commercial property, you're going to depreciate the value of that property over 30 years. However, there's probably flooring, some type of flooring in that property. And unless that flooring is made of some unheard of substance that can stand up to wear and tear over 27 and a half or 30 years, you're going to have to replace that portion of the home faster or sooner than the time it's going to take to depreciate that asset out, right? How do we account for this? Because in the tax code, you only get 27 and a half years or 30 years. What do? Well, there's a section of the tax code that allows you to analyze the property and come up with a way where you can break out assets or portions of the home that would be better to be depreciated over a 5-year schedule or a 7-year schedule or a 15-year schedule. Remember, depreciation is just simply the dollar amount that represents the devaluing of an asset due to use over a period of time. That's all the depreciation is. So all we're saying is, yeah, the property itself, the building, not the land, but the building may depreciate over, for a single family residence, 27 and a half years. But the carpet or the windows or, any number of things, the paint, other fixtures in the house, those things are all going to depreciate faster. And so from an accounting perspective, it would be better to have an analysis done of the property. This analysis is called a cost segregation. So you have someone come in, a professional come in, analyze the property, and instead of having everything depreciated over the general timelines of 27 and a half years or 30 years, you have the appropriate assets depreciated over 5 years or 7 years or 15 years. And then here's another fun thing that you can do. Once you get those costs determined, currently, because of some tax changes that went into effect a few years ago, we have what's called bonus depreciation. Now, bonus depreciation just says that once you have these timelines, so bonus depreciation deals with these timelines. Once you have these timelines established for carpet, plumbing, windows, all kinds of things, after you have that established, if you're inside a window, if the property has been put into service in the particular years at issue, you can depreciate that even faster. So instead of depreciating a fifth of the value every year, under the bonus depreciation rules, you can say, we're going to depreciate all of that in year 1. Right now, because of the rules, you get to depreciate 80% of that in year 1 instead of in year 5. What does depreciation do? Well, depreciation means that you can offset any gain or earning that you've had in the property by the amount of depreciation that you're taking on the property. So you've lowered your tax liability for money that you're still making. Now, the goal with most cost segregation strategies is that we want to make 3 times as much money that we put in to have the study done. That's the general rule. Depending on the value of the property, when the property was put into service as an investment property, and several other factors, sometimes that number can get a lot higher. But that's cost segregation. Knowing about cost segregation can be a very, very powerful tool. Now, some people will say, well, Josh, cost segregation is all well and good, but all of this accelerated depreciation, what happens if I sell the property and then I have to have a depreciation recapture? That's one issue that you could have. So we could have depreciation recapture. Or simultaneously, we could have capital gains taxes, which could seriously eat into my gains on the property when I go to sell it. These are very good issues and important things to know. However, there's a very simple thing that you can do to make sure that these are negligible, if not zero. I can get this one by using one section of the tax code, guaranteed down to 0% every time. How do we do this? We do this by applying a section 1031 property exchange. This is a very particular section of the tax code that says, hey, you have a property, and when you bought it, it was worth $100,000. Now, when you're getting ready to sell it, it's worth $500,000. It is appreciated $400,000. Well, if you went to sell this property, not using a 1031 exchange, what would your capital gains, your gain on the property is $400,000, the difference between the appreciated value and the original cost or basis in the property. And then depending on what your ordinary income tax rate is, you could owe up to 20% of $400,000 on the property. But you don't have to do that at all. In order to avoid all of that, all you have to do is contact someone called a qualified intermediary, a QI, and initiate a 1031 exchange. A 1031 exchange says, okay, you bought this property at $100,000. Here's our nice little property. It's now appreciated to $500,000. Per our previous example, you sell it without a 1031 exchange, you owe capital gains tax on $400,000 of gain. However, in this scenario, using a 1031 exchange, you sell the property at $500,000, and then you take that $500,000 and you roll it into a property, new property. We'll make it a fancier property, multifamily, right? For greater than or equal to $500,000. And so long as you do that exchange within a particular time frame, there are no capital gain taxes on that sale. They are deferred. So this is a way to defer the capital gains tax. Now, what happens when you're ready to sell this property? Do another 1031. And just keep repeating that process until you're ready to move on. Maybe moving on means getting out of real estate altogether. Maybe moving on means that you're not going to sell the property anymore. You're just going to hold it, and you're going to let your heirs or beneficiaries inherit it so that they can get the benefits of that property. Well, if you do that, if you keep deferring the capital gains tax through 1031 exchanges until you die, and then the property is inherited, so we'll put property inherited. Many of you may know where I'm headed with this already. The people that inherit the property get what's called a stepped up basis in the property. That means that if you had a property through exchanges that was worth $1 million, when you die, instead of, so in the typical sense, you would think, well, I had a property worth $1 million. My cost basis in the property was $100,000, which means that the gains is $900,000. And so all of this deferred capital gains tax is going to come due to my beneficiaries, and they're going to have to pay capital gains on $900,000. No. Our tax code allows for a step up in basis on inherited property. So we get a step up, and the beneficiaries receive that property at a new cost basis of $1 million. And they can turn around and sell the property and avoid all of those capital gains taxes that you deferred over your lifetime, right? Who wouldn't want to do that? Not difficult to do. The hardest part is getting started. Now, one thing that we do want to cover before we leave today is we want to talk about a typically misunderstood method of investing in properties that we think will become more useful as time goes on. And what this is it's a property investment strategy that can lead to 4 potential paydays, maybe even more. And what this is, it's typically referred to as subject to investing. So here's the scenario. Person has a home, and there is a lien attached to this home, usually a mortgage, right? So we have person here. He's got a hat on to distinguish him from our other people. Hat investor or hat person has gotten behind on paying this mortgage. So this property is distressed. So then we have real estate investor serving as our white knight coming to the rescue, saying, hey, hat person, I'll buy the property from you and I'll take over paying the mortgage for that property. But you're going to keep the mortgage in your name because I like the mortgage terms that you have. Your interest rate is low. I don't have to go out and find financing. I can use a little bit of my money to pay you for the equity in the property, enter into a contract. So we have a contract that passes between the two saying, you know, I pay you money. So money goes this way and you give me the deed. So this is the contract. This is the deed. Okay. So far, so good. Once you have the deed, you can turn around and rent it to tenants, make money, and that money pays for the mortgage that the hat investor still has. Okay, that's all well and good. But many people will say, what about the due on sale clause? Because we've got savvy investors. We've got people that know what they're talking about. What about the due on sale clause? The lender is going to throw a fit. Sometimes, and usually not. But you have to be able to structure the deal in a way where the lender won't get notified. How do you do that? Well, it's very simple. You don't put the deed in your own name. Instead, what you do is you say, okay, I'm the real estate investor. I'll pay hat investor money for the equity in the house. And then he will transfer the deed to the property into a land trust. Now, a land trust is a particular type of legal tool that allows us to transfer ownership of properties, particularly real estate, in a very easy manner that would otherwise lead to such inconveniences as transfer taxes, subject to, or excuse me, not subject to, but due on sale clauses being called and lenders wanting their money back and all kinds of nasty consequences. If we put or have the hat investor put the deed into the land trust with the hat investor as the trustee initially, then the lender will never know that the actual ownership of the property has changed because the trustee is only the person that manages the property in the trust. In this case, this house over here. The real owner of the property is the beneficiary LLC. The beneficiary LLC is just the person that gets the use of the property in the trust, in this land trust. Now, a typical concern that arises about this point is, yeah, but if the hat investor is the trustee of the land trust, couldn't he just sell the property out from under you? He could, which is why we take steps through some different documents to make sure that he doesn't. First, we get what's called a trustee's deed, where he deeds the property to us. Second, we get a trustee resignation, where he, the hat investor, resigns as the trustee of the land trust in favor of us, or even better, in favor of our real estate investor, or even better, in favor of an LLC that has been set up to be the trustee LLC, so that we're still anonymous, right? We are the manager, who is someone, who can be anyone, of the LLC, hired to manage the LLC, not the member that's the owner, but the manager. And we serve as the trustee, as the manager of this trustee LLC that acts as the trustee of the land trust. We're still anonymous. We control the property. The HAD investor has no way to sell the property out from under us. And that brings us to our last line of defense here, which is called a notice of interest. Notice of interest. Notice of interest is a document that you file with the county saying, hey, I have an interest in this property. It's very similar to adding a second lien on the properties, so that if the HAD investor tries to turn around and sell the property, there won't be able to have clear title pass. So by using the land trust, we've avoided the lender, the due on sale clause, and then we've allowed, or we've arranged a way where we can invest into the property, still pay the HAD investor the equity for the equity in the house, and has allowed you to invest in the property, make money from renting the property out to tenants. So then you have tenants that come in and they start paying you, right? So they start paying you. So there's one payday. It's the second payday. Well, the second payday is cost segregation, right? Because we have an interest in the house now through this beneficiary LLC, we can do a cost segregation study on the house to rapidly depreciate the property. 3, when you're ready, you can turn around and sell this property to somebody else, and you could do a 1031 exchange. And the last thing you could do is you could enter into an option contract to sell the property. And what that allows you to do is you get money from a potential buyer, maybe even the tenant that's paying you up here, to hold open the option for that tenant to buy the property later. They pay you right now a sum of money to hold that option open for a term of years. Then they can develop equity in the property, turn around, get a loan, pay you off, you pay the existing mortgage off, pocket the difference. You've made money 4 ways, and maybe even started a 1031 exchange. And so by building on the principles and the strategies that we talked about in the beginning, you can see how utilizing these strategies moving along appropriately and in ways that are particularly tailored to you will allow you to utilize all of the options and benefits that you have to increase your investing capacity, your investing capabilities, and to make things happen for you in a way where you can sleep at night. You're not going to be worried about disgruntled tenants showing up and messing with your kids on the front lawn. It's not going to be a problem for you. All of this will be handled by implementing certain plans and strategies that are directly applicable to you and will save you money, as long as you work with someone to create a plan that is specific for you and your scenario. So my offer for you tonight is click the link, scan the QR code, do what it takes to take the next step so that you can meet with one of our professional advisors and get a plan that's customized to you. Doesn't matter where you are on the real estate journey. You saw as we progressed through the hypotheticals, we can go from very new in the investing game to very experienced and at a much higher level. And so our hope for you is that you click the link, scan the QR code, set up a time to meet with us so that we can help you achieve your goals and save money on taxes.
All right, let's go through some questions. Josh, thank you very, very much. You really good, really good. So let's start at the top. Hector is asking, when's the best time to create a holding company to hang 2 or 3 LLCs under? Well, in a perfect scenario, you would always set up the holding company first, right?
In a perfect scenario, we would want you to set up the holding company first. But Hector,
obviously we haven't done that.
Yeah.
So when is the best time to do it?
As soon as you can. The best time to do it is as soon as you can. If you haven't already done it, maybe you didn't know about it, Maybe you weren't ready to do it. Maybe you didn't have the money to do it. There's lots of reasons why you may not have done it. You can start implementing the strategies now. It's not a situation where if you already have a property, that ship has sailed. That's not what happens.
But if you've got an existing LLCs and now you want a holding company, they can still do that. We would change the operating agreement of your, and we're simply, before that, you were the owner, you were the member, and now we changed that membership. We would do that in the operating agreement. And Josh, do we need to notify any state agencies or anything to change the operating agreement?
Usually, no. There are some states where you will have to change. Right. So what we're changing the operating agreement is exactly what Dan said. What we're changing, though, is the members listed on the operating agreement. Some states require that to be registered. Most don't.
Perfect. All right. Is there a benefit to having a holding company for each LLC?
No, not really. We can cover a lot of LLCs with one holding company, especially because, as I indicated, the liability only goes from the subsidiary LLCs to the parent. As long as you're governing the parent LLC appropriately, liability won't go from the parent back to any of the other subsidiaries. Very good question.
Now, sometimes I've seen people that have a lot of real estate holdings and a lot of cash have two different holding companies, one for safe assets, one for real estate. But in a I probably wouldn't do that at the beginning, but certainly you could have more than one, and there's nothing inappropriate about it. But we generally don't do that.
It's just needless complexity at that point, unless, as Don said, you want to separate what are called safe assets from other assets. Safe assets are assets that inherently have no way for legal liability to attach. Think brokerage accounts. If you have a brokerage account, just investing money in the stock market or exchange traded funds or whatever, that's not going to create liability. And so you can have a separate holding company for that.
I've also seen where people say, you know what, the most I want in any holding company is about $100 million or $10 million in equity. And so once your estate starts getting big, then you might have 2 or 3 holding companies, but that's a problem for most of us for another day. How's that? Okay. Michael, I'm confused on the holding company's limited liability when it owns 5 pieces of property. Well, it'll never own 5 pieces of property. It'll own 5 LLCs that individually own properties. How are they separate when commingling? Did that answer the question?
I think so. I can elaborate just a touch on that just to get some more detail. But Don's answer is perfect. It won't own 5 properties. It will own 5 LLCs. The LLCs own the properties. I mentioned at the beginning, me owning 5 properties is inherently different under the law from me owning 5 LLCs that each own a property. That legal difference and distinction is what's key in asset protection. That's what we rely on in putting up these strategies. Another related piece of that is something that we referenced a little bit ago, which is that liability in properly structured and properly used entities only goes from subsidiary to parent. It doesn't go from parent back to subsidiary. And that's an important distinction as well.
Good. Michael's also asking, if you are a single member LLC, how is Wyoming charging order protected from owners' distributions from a tax perspective? Is that income protect? Okay, so if distributions come out, are distributions protected, or are they only protected inside of the LLC?
So if you make a distribution, when there's a judgment against the entity under the charging order, that distribution would go to the judgment creditor, the plaintiff in the lawsuit. The key is to make sure you don't ever make any distributions. And you, as the owner of the entity, are in control of that, whether or not a distribution occurs. A distribution here is not defined as any money leaving the entity. That is what we would think of colloquially as a distribution of funds, right? It's what I think of still. But when we're talking about the term of art of an ownership distribution, What we're talking about is a very specific transfer of money going from a business entity to the member or owner of that business entity as a repayment or a payoff or profit for investment into that entity. There are other ways to get money out of the entity that aren't distributions, and that's how we utilize that particular strategy.
And Michael, the key, I think, is having an operating agreement that gives you, even under duress, it gives you the power to distribute or not distribute, or loan money, or call it a management fee, or call it call it lots of things. You might very well distribute available funds annually but if there's a charging order against your interest, we're going to look for other ways for you to get money out, but not call it a distribution. And the key is your operating agreement. And I've seen way too many operating agreements that say we're going to distribute available funds annually. We're going to distribute pro rata, which what if I wanted to do non-pro rata? What I want to distribute to everyone, but partner number 3 has a charging order. So no, I don't want to distribute to him this year. We're going to loan money, we're going to lend money, we're going to have him do a service, but the key is your operating agreement. And Anderson, forget everything else that Anderson does, and they do a lot of good things, but the strength of what I see Anderson do is they've got incredible legal forms. And I've gone through their operating agreements, and it's going to land like a thud on your plaintiff's attorney's desk. I mean, it's beefy, but it's considered every possible scenario where you might be, and still you're in control, no matter what. I love Anderson for a lot of reasons, but the number one reason we refer people, I love their legal forms, especially the operating agreements, the LLCs. Okay, one last question from Michael. Can you declare a partnership status with only one individual? I think you've answered that very well. However, could we have a corporation and you? Yeah, could we have an IRA and you?
Yeah, but I don't love that strategy for reasons that we won't go into tonight, but we can talk about that.
Okay, Rogers, good to see you, our old friend. Can you do a 1031 exchange on a house you built with the intent of selling it within 12 months?
I don't see why not. I'm unaware of any restriction on that, Rogers.
Yeah. Okay. Let's see. Can you talk about recapture depreciation? That's confusing me, and it confuses a lot of people. Yep.
To be fair, Alexis, I just figured out what depreciation recapture is, and I've been doing this for almost a decade. So really simply put, and it goes back to what is the definition of depreciation? Depreciation is the cost for use of an asset. That's important. It's like what it costs to go out and get something to use it in your business. And so when we recapture depreciation, excuse me, I got ahead of myself. See, and this is what happens when we talk about depreciation recapture. We go too fast. So when we take depreciation against an asset, we are declaring for tax purposes that that asset has lost value until the taxable book value of that asset reaches 0. That's what's happening from a tax perspective. So if you have an asset that has been depreciated, and then you turn around and sell it and get money for it, the IRS is like, wait, you told us for tax purposes that asset was worth $0. Then you went out and sold it for not $0. So we are going to impose a tax on the sale of that valueless asset that you got value for, obviously, and that tax is going to be 25% because we're greedy and it's an overblown bureaucracy. Well,
and Alexis, one of the things you need to remember about recapture depreciation, I've seen a lot of people say, well, I'm not going to claim the depreciation on my properties this year because I'm worried about recapture depreciation. They're going to charge you that regardless of whether you claimed it along the way or not. Doesn't matter. And so I always claim depreciation on my properties, and when I can, I cost seg it and speed it up so that I've got a bigger tax deduction now, which gives me more money to invest in real estate now, and I'll worry about the can that I kick down the road later. Okay, can you talk about equity? And Josh, you did mention you would, in a subject to transaction, you would pay them for the equity, but you don't necessarily have to do that, do you?
You don't have to, but the reason I highlighted that portion is because you have to induce the seller to do the deal with you, right?
Right.
And so think about it this way. Let's say you had something, you have an asset, and you have to make payments on the asset, but you still get use out of the asset, right? If I'm the person that owns the asset, I'm still using it, even though I'm in hock for it, I've got a loan out for it, and you come to me and you say, I will take over the payments for that. Well, that doesn't help me as much as it helps you, because then I lose the asset, even though I don't have to pay for it. What if I'm using that asset either to live in or to help me make some of my money or to help, to do something with? That person may still have a use for it or still have something invested into it. So do you have to pay for the equity that the owner has? No, it is not a requirement legally. You can enter into an agreement where that's not required, but it can help to sweeten the pot and get the deal done. That's why I brought it up.
Okay, Patrick, thank you for that. Patrick is asking, what's the difference between placing a property in an LLC or placing a property in a trust?
The difference here is going to be between the legal form available. And I don't mean the legal form as in the document, but the form of the actual legal entity at issue. An LLC is a separate legal individual. It has its own rights, responsibilities, duties, and obligations, as well as abilities under the law. And therefore, when you transfer a property from one entity to the other, or a person to an entity, that's a taxable event. That's something that has to be accounted for on the government side. Whereas, because a trust, is not, strictly speaking, a legal entity, transfer taxes don't apply. Not applicable in the majority of states. The legal liability for that asset, with very few exceptions, still lays with the grantor of the trust, the person that created the trust and transferred property into the trust. And so it's a question of the separate and distinct legal doctrines applicable to those entities, or the entity and the trust, that come into play. And that's the difference between transferring the property to an entity and to a trust.
And you'll find out, Patrick, depending on what state you live in, if you live in Florida, Anderson might very well recommend land trusts going directly into your holding company and not using an LLC. And so it depends a little state specific. Do you still have that slide up? If they wanted a consult with you, where would they? You put that back up there.
Certainly.
Because sometimes, Patrick, sometimes these are state specific questions. And the answer is, it depends on where you're at and kind of what you're doing. And Patrick, I'm assuming you're talking a land trust, not a revocable living trust, which is a very different animal. Okay. Curtis, amazing, Josh. Thank you. Do you have partners in Canada who could roll out some of these strategies?
Unfortunately, not yet. However, we do, Anderson Business Advisors does business with Canadian investors and Canadian nationals that are investing in the States. So if you're investing in Canada, not any place I can point you to right now. We are working on that. But if you're a Canadian investing in the States, we can absolutely help you. You should set up a time and we'll work with you on that.
And Anderson is really good at that and helping you get the ITIN number and working with your your Canadian corporation, working with in conjunction with your US corporation and avoiding some of the double taxes that exist. And so, yes, but LLCs don't work in Canada. and trusts work a little bit differently, and corporations work very differently. And yeah, but Anderson has some really they're good at this. Okay, Sonny, how do you prove you're the owner of a Wyoming holding company if your personal information is not stored with the state? Good questions.
An excellent question. One of the ways that you do this is through the operating agreement. The operating agreement, when we create an entity, is all powerful. It's the constitution of the entity. That's the best way I've found to describe it. It lays out all of the whys, the wherefores, the wherewithals, and what you're going to do with the entity. It's all right there. It also has the membership in there. So that's one way. A second way that's a little bit more complicated and complex, but has the feel of authenticity and authority, kind of the ring of authority with it, is that when you create an entity, you have to file, no matter how the entity is taxed, you must file for an EIN, an employer identification number. It's also called a TIN sometimes, taxpayer identification number. That number is attached to, due to some legal precedents that the IRS has set, it's attached to what is called a responsible party, which must be a human, living, breathing individual. And that is tracked through your social security number. So if you have to prove ownership, you can always go back and say, somebody say, I own that entity. And you can say, then why is my social security number the one that's attached to that EIN as the responsible tax party? So two ways to do it. Usually the operating agreement is more than enough. Second way to do it is you can track it back to the IRS saying, here's the documentation.
And Sonny, sometimes banks want to see,
Sorry,
they want
Don.
to see your name on it, and on the state's website. But Wyoming doesn't ask who the manager is. They don't ask who the member is. It would be, but you own it. You have the operating agreement. It shows that you're the member, maybe and the manager as well. But yeah, and I understand your problem, but it would be the operating agreement. Okay, is there a way to minimize the $800 extortion fee that California charges? I'm sorry, I read a little into that question. Sorry. When you have so many entities, how do you avoid the $800 per entity filing fee in California?
Right. So I too read the extortion fee into that question, Don. So we were on the same page there. Couple of ways you can avoid it, and then a very simple way that you can deal with it but not avoid it. So we'll start with the avoidance strategies first. Easiest way to avoid that fee is to use a specific type of trust. It's not a land trust. It is not a living trust or a revocable trust. It is what's called a business trust. A business trust is set up like a trust, but it has the capability written into the trust documentation to switch its nature and become an LLC whenever the beneficiaries want it to become an LLC. This type of entity is not subject under California law per a court precedent in the state to that $800 fee. Now, we here at Anderson have set up several structures where we have utilized this statutory trust, specifically a Wyoming statutory trust, and we've specially drafted our own Wyoming statutory trust to comply with all the complexities of doing business in California with an out-of-state entity in order to avoid that fee. It is a very useful tool, and a lot of people choose to use it. And so that's the easiest and best way to avoid the tax altogether. It's simply not applicable to those entities. The franchise tax board, the bureaucracy that you're looking to avoid, can't touch those entities. They just can't do it. And so you use that structure and strategy. It's very similar to kind of the bare bones structure that we talked about tonight. There are some nuances and differences between the Wyoming holding company and the LLCs and et cetera and so on, particularly if you're a Californian living in California and investing in both the state of California and outside the state of California. So there are some nuances there, but that's the easiest way to avoid it. The easiest way to deal with that franchise tax, in my opinion, and this is just my opinion, is to just pass the cost on to the tenant renting the property. If you do the math, $800 divided by 12, it ends up being like something like $67 a month. So if you jack up rents by $100 a month, which in California anymore is probably not even going to be noticed, you can factor it in that way. But I understand the impulse to want to avoid it, and the Wyoming Statutory Trust is the very best way to do that.
And a couple of comments on that. Clint has been on our stage, and Kendall, if you wouldn't mind putting that he taught a magnificent webinar on Wyoming statutory trusts, and specifically for Californians to avoid that $800 minimum tax due. So Kendall, if you wouldn't mind putting that back on our YouTube channel. A lot of these webinars that we've done kind of rotate in and out, but we'll try to make sure that that's available for the next week or so. The other thing, John, remember that it's a minimum tax due per entity. So if you're making money, you're not paying taxes. It's not a filing fee like most states and a tax, and it's not a filing fee plus a tax. It's a minimum tax due. So the California Franchise Tax Board really only kicks you when you're down. When you're not making money, that's when you see it a lot. Okay. Samara is asking, what about land trusts in California? There's no state statutes that allows for it, but they do allow for grantor trusts. And so we use them all the time. Yep. But there's no state statutes, or is there any laws prohibiting them from California using land trusts? The only thing that I've seen people get in trouble with is in California, if you're using that to avoid your Prop 13, and try to transfer it to a non-related party and avoid the property tax reassessment, you're going to get slapped upside the head for that pretty hard. Any comments on that, Josh? And
hard. It's going to hurt.
Yeah. Okay.
That's why we like the Wyoming Statutory Trust. We used to use a lot of land trusts in California. These new property tax issues were raised, and so we looked for a different way, and the best one is to use the Wyoming Statutory Trust.
Okay, Josh, we are having a whole bunch more questions than we ever have time to do, and so students, we're going to go till about 20 minutes past the hour. Josh and I are going to go as fast as we can, and after that I encourage you to seek a consultation. It's right there. We've made it free, and that way you can ask specific questions to Josh and Anderson's group, but we'll try to go as fast as we can. Can I set up a holding company even if I don't have real estate properties?
Yeah, absolutely.
We see that a lot for large brokerage accounts, cash accounts. You do it. You hold any assets. Yeah.
Intellectual property.
Yep. Why wouldn't I use why not just umbrella insurance to cover? Why do I have to have all these legal structures? Why can't insurance just cover me?
Possible they could. However, remember, insurance companies are companies, and they answer to shareholders, which means they have a profit-seeking motive. Point being, they are invested in not paying out your claim. And so they write the policies such that if they can find a way to either not cover or reduce coverage or have no coverage to begin with in the policy, they're going to do that. And so some umbrella policies may cover all of the stuff that we're talking about. In our experience, very few do. And the best approach is to use what I call the carrot and the stick. The carrot is the insurance company money saying, we will settle for this amount of money right now today to make you go away. And the stick is, if you don't settle, you get to deal with all of our entities and all of the ongoing litigation costs and all of the pain and torment and stress, which is often understated for legal problems and for litigation, that goes along with that. So you get to choose plaintiff, carrot, or stick. So a combination of both is generally best.
And Samara, I see a lot of especially accountants saying, you don't need all this. You're just going to complicate your life. Just carry more insurance. And there's two things I want you to understand about umbrella policies. Number one, umbrella policies, let's say you're going from $100,000 to $1 million. Umbrella policies only pay if the primary policy pays. If there's an exclusion at the primary level, it will never pay at the $1 million level, ever. It doesn't do that. Umbrella policies only pay, but if there's an exclusion, read your policy and look at all the things that it doesn't cover. My homeowner's policy is like 26 pages long, and there's 3 pages that cover what we will cover and a whole bunch explaining what doesn't. The other thing that I want you to remember about carrying umbrella policies is when you carry too much, all of a sudden you become a target for a lawsuit. And so we always want your insurance to be your first line of defense, but then we use legal structures after that to back that up and to protect you. Any comments on that, Josh?
Nope, I agree.
Cool. All right. With the fancy regs that take effect January 24th. An anonymity. Oh my gosh, are we losing all our anonymity? Talk to us about the new regs that go into effect January 1st.
This is one of my favorite questions because it speaks directly to like everyone's fear of like, are we all going to be found out? No. If you look at the legislation and the operating kind of the enforcement mechanism that the federal government's going to have, all it does is it requires the states to report ownership information to the federal government. It does not create a publicly available database, 1. 2, that information is supposed to be kept at the same level of secrecy or maybe confidentiality is a better word, as tax returns and other information that the federal government keeps on us. Whether or not you want to believe them is a different story altogether. And it's only supposed to be available to other branches of the federal government under subpoena for and under warrant for criminal activities. It's really another step in the anti-money laundering provisions of the law that they're putting in place, because the ones that they were first had, for whatever reason, they found they didn't work as well as they wanted them to. So no, it doesn't affect your anonymity, at least in the current iteration that we see that's going to go in effect in the 2024.
I see no effect on this for the average investor right now. You've got a Wyoming holding company. Yes, the federal government knows now who owns it. Those of you that aren't familiar, they're requiring now, we need to know who the controlling party and the members are. If you own 25% more or more of a business entity, they're requiring that the federal government. But look how hard it was for us to get Donald Trump's tax returns. It's not a matter of public record. It's just the federal government. Do I like that? No, but that's the law. Okay. Is there a considerable threshold where you'd need to start asset protection? Is it $1 million, 10 million, 100 million?
I don't know. And the reason I say I don't know is because it's whatever you feel you can afford to lose. That's the answer. And so if you have, let's say you have 10 investment properties, but those 10 investment properties bring you enough money where you and your family can live comfortably, but it doesn't rise to the amount of, let's say it's only $1 million, and you say $1 million is nothing. Well, if we took out not just the $1 million, but all of the cash flow that those properties generate for you, then you don't have your own house potentially, or food, or all of the money that you need to live off of. So $1 million for some real estate investors is a drop in the bucket. It's not a problem because they have so many other properties that generate the cash flow they need to continue their lifestyle. But if you have $1 million in equity in real estate properties and that's generating what you live off of, you should have all of this protected under asset protection so that one lawsuit doesn't wipe out your entire way of life. So that,
and I look at it another way too. Mm-hmm. Do you own an asset that causes me risk? Mm-hmm. I've got a piece of raw land. I only put $10,000 in. If I lost it, it's no big deal. But I got kids riding bikes on it or shooting, little ducks or whatever they're doing. Could something happen on that raw land that comes back and affects everything that you absolutely. Mm-hmm. And so if you own a dump truck, you own a piece of heavy equipment, it's an old dump truck. I don't care if I lose it, but could it cause risk? Could it bring liability to what I'm doing? Absolutely. So look at it from what I'd stand to lose, but also look at it from what risk does it pose to my estate?
Mhm.
Would you need liability protection for a retirement account or an asset protection for an IRA? And you know what? I taught a class on this probably a couple months ago. It's on our YouTube channel, How to Protect Retirement Accounts. And we went through inside sources, how to keep from blowing it up yourself.
Mhm.
And we talked about all different types, including lawsuits, but we talked about unrelated parties and I don't know, all kinds of things. But we also talked about IRAs and all this, what was ERISA protected, meaning federal laws. We also talked about state regulations, and because IRAs are not federally protected. And so now you look at state laws, and if you live in California, they give they give a lot of liberty to a judge to rip into your IRA.
Mhm.
There are 6 states that would protect traditional but not Roth IRAs. Minnesota caps out their protection at $68,000. We look at the state laws, and some of them will protect inherited IRAs, some of them won't. Very, very different. So do you need asset protection for an IRA? Yes. So look at that webinar, and I think that's the best resource. It'll be on our YouTube channel, How to Protect Retirement Accounts. Okay, when the holding company is sued, will the LLCs and properties be affected?
No, mainly because I have a difficult time thinking of a hypothetical situation where only the holding company would be sued. The other thing to remember is that the holding company, the only asset it owns is the other LLCs. And the only way that a plaintiff is going to be able to get the asset in those other LLCs is if the event giving rise to the liability happens because of one of those assets.
Standard, the holding company doesn't own risky assets. It owns safe assets. It owns interests in other LLCs. It may be a bank account, maybe a cash account, but those things don't cause they're very rarely. I agree with Josh. I don't see a lot of potential for the holding company ever to get sued. Okay, John is asking, if I bought investment property in my name, now want to change it to a Wyoming LLC, is the anonymity lost or impossible because the LLC, well, because the property was in his name? What do we do with that?
So here's the thing with this. The anonymity is not going to be perfect in this case because the property was already in your name. However, transferring a property from yourself to an entity that nobody knows the owner of isn't going to have a massive effect on anonymity. It's not going to cause a huge problem. It's not ideal, but sometimes that's how deals get done. And if the issue for a real estate investor is having perfect anonymity or getting the deal done, having an asset that's going to generate income and wealth for you and help drive your, the success of your goals, go get the asset. We'll help you protect it the best way we can, and then we'll move you forward.
But John, remember, anonymity is not the ultimate goal. Asset protection is the goal. Remember the O.J. Simpson case where they take California home, they take the white Bronco, but they can't touch his NFL pension plan. It's protected by ERISA. They can't touch his home. He's got millions of dollars into a Florida home. They can't touch it. He's standing behind bulletproof glass going, neener, neener, neener. You can see me, but you can't touch it. That's good asset protection. Asset protection is the goal. So let's say you've lost the anonymity. Everyone knows in town that you own the property, and now it disappears into a Wyoming holding company. They still can't touch it. And you might get sued, but they're not going to get the assets. Okay, Amir, if you have a Wyoming holding company that is anonymous, can a court force the disclosure? Yes, they could. If yes, is the LLC no longer visible? Do you have to dissolve it and create a new one?
No.
Again, they're going to have a hard time attaching to any assets inside of that.
Mhm.
And that's it again, anonymity is not the goal. Let's say the property is in Tennessee. You've got to hire a Tennessee attorney who then works in conjunction with your Wyoming entity attorney, and the two of them have to talk back and forth. You've tripled the cost of litigation before they even sue you. And the chances of them prevailing and taking the assets are close to none. That's good asset protection.
Yep.
Is there an annual filing or obligation cost for each LLC, or only at the initial setup?
There is an annual cost for each LLC in addition to an annual setup or initial setup. It's a cost of doing business. It's a cost that it's a tax deductible cost. It's a fee that you can take, but it is a cost. If you look at the comparable situations, do I pay a small cost now or do I pay a large cost later? Even if the small cost is every year, the best business decision matches with the best asset protection decision, which is to take a small cost each year along the way in order to have the asset protection to prevent against the big cost.
Yeah, and Curtis, I would say there's a couple states like Missouri. Once you set up the initial, there's no annual filing fee. Good. Well, but unless I have properties in Missouri, that doesn't do me good. It's nice to know, but it doesn't help. But most of the time, that annual filing fee is going to be $75 to $100, unless you live in states like Massachusetts, California. But again, that's the cost of doing business in your sunny state. What happens to depreciation? We got one more question, and then I'm going to have to turn it off for the night. But really, take advantage. We can't get you with a better law firm that can answer your questions than Anderson Business Advisors. Josh is right in the middle of it. Okay, what happens? Oh, we answered that. What happens to depreciation declared previously if you do a 1031 exchange?
My understanding is that it is still recaptured, but a lot of that, because the sale is happening, what it does is it depreciates, or it doesn't depreciate. It diminishes the amount that you would have to declare in capital gains. So it does cause some problems looking at a new target property in the exchange. But again, looking at the comparables here, looking at, do I want to save a lot of money on the deferred capital gains taxes by paying a little bit of money on the depreciation that was previously declared? Or do I want to pay all of the tax all at once? It makes better sense to take the depreciation earlier. The other thing to think about is the cost, is the current value of a dollar, right? A dollar now is always worth more than a dollar in the future because of how inflation works. So if you take the cost segregation and depreciate now, the depreciation is going to be more valuable for you in the present than the cost of the depreciation recapture in the future. So there's a couple of reasons arguing for, not from an emotional point of view, but just from a paper statement money point of view, that you're going to want to take the depreciation recapture as compared to taking the capital gains hit or not taking the cost segregation study depreciation at all.
Great. All right. There's so many questions. I've been rifling through them a little bit, and again, we're going to be here all night if we do this. So I apologize sincerely. We do have a hotline at Protect Wealth. You're welcome to call that tomorrow. It's 800-276-1430. But I really encourage you to contact Anderson, because they can hone it down and be very specific with you and be able to answer your questions. So I encourage you to do that. Josh, any closing comments for you?
Just remember, this is all very personalized and very specific, and that these structures have to be developed and put into play for your specific goals. We really want to talk to you. We can help you. We are excited to help you. Please get in touch with us so that we can talk to you about your personal situation and help you out.
And I absolutely agree with Josh. Both of us are in this industry because we want to help people. I hope you see that in our hearts. There are real solutions for real people, and they're not just. I've seen people save tens of maybe hundreds of thousands of dollars by implementing these strategies. Thank you for the thumbs up and hearts. But Josh and his team, I know a lot of their attorneys. I don't know everyone on your team now. It's grown really big. But I know the principles, and I know their heart's in the right place. And I love your legal forms. You know what? You've got a big organization. Have you ever dropped the ball on any client? Yeah, I can see that. But I think every company does. I love what you do. And Josh, thank you so much for your time and your very good presentation. Students, again, thank you for your time. Thank you for being here. If you have questions, please take advantage of that consult. And then if you schedule a time with them, be true to that time and show up for it. That's an important thing. All right. Thank you all for being here. Have a great night. Good night.
Thank you.
Bye-bye.